If you're sued for a debt, your debt collector is probably going to send you something called interrogatories. I'm going to teach you what interrogatories are, how you can respond to them when your debt collector sends them to you, and then how you can use them to beat your debt collector in your lawsuit. Now, an interrogatory is really just a legal form that you fill out and use in a debt collection lawsuit. I've got those forms available for you on our website, debtbrief.com. You can find a link to it in the description. Go to the website, buy those forms, and then I'm going to tell you in the rest of this video how you can use those forms. Now, the first question is, what are interrogatories? Interrogatories are written questions that one party in a lawsuit sends to another party in a lawsuit that the other party is required to answer under oath. And when we say that they're answered under oath, that means that you have to answer those the same way as if you were in a courtroom sitting in front of a judge. And really, they're just questions about the case. A debt collector might send you a form. It'll be called interrogatories or discovery requests, and it'll have just a bunch of questions there. What you want to do is you want to look at those questions and you want to see, how am I going to answer these to make sure that I don't ruin my case? Now, every state's rules on how to deal with interrogatories are just a little bit different. So the first step that you want to do when you're responding to interrogatories is find out what your state's court's rules are. You can usually find those court rules. First of all, maybe you can call the clerk at the court and they will tell you where they can be found. They might be on the court's website, or you can try searching online for something like the name of your state, rules of civil procedure. Not all of the state's rules are called the rules of civil procedure, but it'll be something similar like that. Now, some states will have limits on the number of interrogatories that can be sent. It will give specific instructions on how they have to be formatted, things like this. So you really want to check out your court rules so that you don't mess this up and you do it exactly the way that the court wants you to do it. Now, as far as the format, and this is a general format, your court may have more specific rules, but generally when you receive interrogatories, it's going to be on a court pleading document, and then it will say something like Interrogatory 1, and then list the question. Interrogatory 2, and then list the question. It'll just be a list of these questions. So what are some examples of things that you might see? A debt collector might send you an interrogatory and it'll say, Interrogatory number 1, describe the goods or services you received in exchange for a promise of payment. Interrogatory number 2, describe any reasons why you think you may not owe the debt. Or interrogatory number 3, explain how much of the debt you believe you have paid to date. So they'll kind of be in that format. What you need to do when you respond is on your response, you'll put it again on this court pleading document. It'll be called responses to interrogatories or answers to interrogatories, something like that. And you have to restate every question. So you'll need to type out on your document all of the questions again. Interrogatory number 1, describe the goods or services you received in exchange for promise of payment. Interrogatory 2, etc. Now, under each question, you'll want to then add in your response. So it'll say interrogatory number 1, describe the goods or services you received in exchange for promise of payment. And then you'll type below that response. And then you're going to write in your response. And you're going to do that for every one of those interrogatories. Now you're going to say, well, how do I respond to these? Now, if you think about those questions that I just asked, the sample interrogatories, what you've got to be careful about is that these are kind of trick questions. What the debt collector is trying to do with interrogatories really is get you to respond in a way that he can then take your responses to the judge and ask the judge to grant what's called summary judgment in the debt collector's favor, because you've answered the questions in a way that you've essentially admitted that you owed the debt, so there's really nothing to decide, and the court can just grant judgment against you. So this is really one of the big problems that I see debtors that have been sued make, is answering interrogatories and other types of discovery requests. So you want to be careful and think about, they're trying to trick me in asking these questions, so how can I answer this question in a way that I don't get tricked. So let's take that first one for an example. Interrogatory number 1, describe the goods or services you received in exchange for a promise of payment. If you type as your response, I received this good, or I received these medical services, well, now they've got you admitting that you promised to pay in exchange for that good or service. So, how do you respond? Well, I did not receive the goods or services as promised. Maybe you think that, well, they didn't do exactly what I thought they were going to do. Or maybe it's a medical debt. Well, I didn't promise to pay this in exchange for a good or service. Maybe it's your insurance that was supposed to pay. So you would say something like, well, I didn't promise to pay. And so that's going to be your response. So what you need to do on these interrogatories is think about, what is the debt collector trying to get me to say? And then you want to try to avoid that as much as you can. Now, remember that, you are under oath when you're answering these questions. So you do still have to be truthful. And frankly, maybe you did promise to pay, and maybe you owe the debt, but you're trying to negotiate it down. And if you have to answer these questions in a way that you admit that you owe the debt, then what you need to do is you need to take the remaining time of responding to these interrogatories and start negotiating with your debt collector. So every state, again, is going to be a little bit different. Most states are around 30 days to respond to interrogatories. So what you want to do is you want to use that 30 days to start negotiating the debt and start negotiating a payment plan or a partial payment, something like that, because that if you respond to these questions truthfully, they're going to turn around and get a judgment against you. If that's something you want to avoid, then you need to start working on a negotiation now before you have to send your responses. Okay, now, why are interrogatories important? I'll tell you one of the biggest problems that I see. Again, I noticed that I mentioned that interrogatories are a big problem for people that have been sued for debts, because the biggest problem that we see is that people don't respond to them. That is the number one rule, is you need to respond to these, because what happens is if you don't respond to the interrogatories, the debt collector is going to go to the court and say, I sent these interrogatories to the defendant. The defendant is required to respond to them under court rule, and the defendant did not respond to them. So because the defendant is not participating in this case the way that they are supposed to under court rules, I am asking the court to grant judgment in my favor. And the court, frankly, is going to do that in a lot of circumstances if you fail to respond. So that's the number one issue, is they're important because you need to respond to them. The second thing that happens, though, is what we just mentioned. You give a bad response to those interrogatories, and they turn around and they use your responses against you and file a motion for summary judgment. So it is very important when you're dealing with interrogatories and other types of discovery requests that you, number one, respond, and you, number two, respond in a way that isn't going to harm your case if you can help it. And number three, if you are going to have to respond in a way that's going to be harmful to your case, now is the time to settle the debt. Now, the other thing that you can do when you respond is object to the interrogatories. Now, this is a little bit more complicated. It's something that, frankly, lawyers are going to have a lot more experience with, but you can do some simple things. If, there are some sample objections, things like if the question just doesn't make sense to you, you don't really understand what they're asking, you can say something like objection vague and ambiguous. If, for example, the court rules allow them to ask 25 interrogatories and they've asked you 30, on the last 5, you're going to object because they exceed the scope of what the court allows. Something like that. You can, search for different objections or look at your particular court's rules to see what some objections are. But just note that even if you object to these questions, in some circumstances, you may still be required to answer the question, but preserve the objection by noting the objection and then answering the question. So, objections can be a little tricky. It's really more in the realm of what a lawyer's going to do. But, I think it's important to at least note that, that's an option for you. Now, how can you use interrogatories to beat your debt collector? Number one, if you're responding to interrogatories, you want to do it in a way that they can't get a quick and easy judgment against you. And if they know that you have defenses to the case and you are going to fight and go to trial, they're most likely going to be willing to drop their demand down and reach some sort of negotiation in the middle. So number one, by responding in a way where you don't admit that you owe the debt, you really can gain some leverage in settlement negotiations. But the other way that you can use them to win is doing the exact pattern of what I just taught you that they do back to them. That means sending your own set of interrogatories. So again, you can do two things. If you send the interrogatories and they don't respond within the time limit, you can then file what's called a motion. Again, we've got form motions for sale on the website, debtbrief.com, but you can use these form motions and ask the court and say, hey, they were supposed to respond to these interrogatories under court rules. They did not, so we are asking the court to dismiss the case. Now, there's a pretty good chance that they may respond to the interrogatories if you send them. If they do, again, you're going to do the same thing. You're going to ask questions in your interrogatories that hopefully will prompt a response out of them where they admit that they can't prove you owe the debt. So when you're writing these interrogatories, think about what are some questions I can ask them that might require them to answer in a way where they can't admit you can prove that you owe the debt. So, this is really going to be more useful when you've got like a third-party debt buyer where the person that you originally contracted with for the goods or services is not the person who is suing you, but a junk debt buyer or something that is coming in and bought that debt and is now suing you, and they may not have all the information that's required. So, what are some examples of some interrogatories? Describe all contracts that you maintain that state that defendant owes the debt, or describe the goods and services the original creditor provided to the defendant. Again, if they can't answer that, they don't know what the goods and services were that were provided because they bought this debt and didn't get any of the other information. Boom, now you've got something that you can take to the court and say, they don't even know what this debt is for. So how can you say that we owe it? Ask something like, describe how you came to purchase the debt. Describe all documents that you have that you believe demonstrate defendant owes the debt, or describe every document in your file on this matter. So you can kind of learn what documents they do and don't have. You can ask them to identify any arbitration agreement that may govern this debt. There may be an arbitration agreement that they were supposed to take this into arbitration rather in court. And then if you find out there's an arbitration agreement, then you can file a motion for arbitration that dismisses the case and requires them to go to arbitration, which they're going to be a lot less willing to do. Really, the sky's the limit as to the types of things that you can ask in interrogatories. And some of these examples I've given may apply to your case, some of them may not. I've really just given these as, information and examples. What you want to do is sit down and think about, what can I ask in my particular case that's going to be helpful and maybe hopefully prove that they don't have all the information they need to prove that you owe the debt. So that's kind of it on interrogatories. Hopefully this little tutorial has been helpful to you if you are in a situation where you need to either respond or send interrogatories. Head over to debtbrief.com. Again, we've got forms. We've got responses to interrogatory forms. We've got interrogatory forms that you can use to send your own interrogatories. We've got motion documents, answers to summons and complaints. If you're just being sued right now, we've got those forms. It comes when you purchase the forms. It comes with a free ebook that will explain to you how to use the forms and what you can do and how you can use them in your case. If you would like to have some coaching or tutorials on other things similar to this video here, you can head over to debtbrief.com or send us an email at contact@debtbrief.com, and we'll see if we can help you out there. If you need a referral to a lawyer that can handle your case or give you some legal advice, we can do that as well. Also, if you think that you have reason to sue your debt collector under the Fair Debt Collection Practices Act, send us an email at contact@debtbrief.com, and we can get you a referral to a lawyer who can take a look at your case and see if maybe you have a case or a reason to sue your debt collector and you can get some money for yourself. And attorneys on those types of cases typically can take them under contingency fee where the creditor pays their fee and you don't have to. Likewise, if you are in a situation where you think that maybe it's time to file bankruptcy rather than fight these debts, send us an email again at contact@debtbrief.com, and we will get you a referral to a lawyer who can possibly take a look at your case and see if bankruptcy is right for you. So again, check out all that information in the comments below, in the description below. Leave a comment, like, and subscribe. That really helps us get the word out and help as many people that are dealing with these debt collection issues as possible. So thanks and good luck in your lawsuit.